I need accommodation for today, ma'am.
Okay. On the prayer of MS M. Borman, learned amicus brief for the appellant. On the prayer of MS M. Borman, item number 4. Learned amicus brief for the appellant, comma, the case is possible for the day.
Okay.
MS Avego. Learned additional public prosecutor has consented to the safe prayer.
I beg to mention listing criminal appeal matter, orders matter pending matter. Next week, any
Next week,
mile. Always.
orders.
Mile.
I have also similar criminal appeal for orders next week, my lord. The 21st month.
Don't choose the date next week.
All right. My lord. Similar, my lord. This is I for bail, your lordship, in file in criminal appeal, my lord,
Fine, what do you do?
for orders, yeah. Obviously.
Wait, please, lordship. I beg to mention item number 3, lordship, with the consent of the others, lordship. National password for the day. I have some for personal inconvenience, lordship.
Mr. You have informed the other side?
Yes, yes, is there, lordship.
Okay.
Once
Mr. S. N. Krishna Troy, learned counsel for the appellant, and Mr.
yes, for your lordship.
S. Paul, learned counsel for the respondent are present. Full stop. Mr. Krishna Troy has sought an adjournment in that case. With the consent of the learned counsel for the respondent. So the price is allowed. The case is possible for the day.
Your lordship, if possible, a date may be fixed on
No,
next week.
no, will not fix it.
May I please, your lordship? I beg for listing, lordship, for orders, lordship.
You give it to the court master.
Oblige.
We will look into.
Please, my lord.
Yes.
My lord, with due consent, I beg to mention item 8 to 10, my lord. We are also led by senior counsel, Mr. K.
Mr.
A. Bhatra.
Batra. A.
A. Bhatra, my lord. My lord,
Okay. You are appealing for whom?
my lord, we are appearing for appellants in item number 9 and 10.
9 and 10.
We are the respondent in item number 8.
Okay. So,
My lord, an adjournment for a week.
okay. Mr. A. Batra. Learned counsel for the appellant in 9 and 10 and for the respondent in 8. Come out with due consent from the other sides. With due consent from the other sides. Has sought an adjournment on the ground of personal difficulty. Full stop. The prayer is allowed. Raise the cases after
A week, my lord. 1 week.
after 1 week.
Highly
182 weeks by the house.
Ordered में 10 items.
Mr. Mondo, this will take the first 2 partner matters thereafter. So you need not be here up to 12 o'clock.
Items 12 and 13.
No. But disable question. Disable question. Kali, common je. Yes, MS Bhuya, anything
Lordships,
to supplement?
lordship,
Hey, doctor, এইখিনি গুছাই লওক।
observation that
পানী বটলটো গুছাই দিব।
lordship, may I refer AR 64 SC, no, not document. AR 1957 SC 216.
Agnu or what?
This is Balbir Singh versus State of Punjab. Paragraph 14,
Paragraph
14, my lord.
তোমার হ্যাঁ দুটো আছে হ্যাঁ এই এইটো দুটা লাগি আছে অৰিজিনেল গুলো দুটা খুলি দিয়কচোন
Worship, paragraph 14.
1 minute
Yes.
para
14, your lordship. We proceed now to a consideration of these arguments of Mr. Sethi. There can be no doubt that the two confessions, one by the appellant and the other by Jagbir Singh, vary in some particulars. One important point on which they differ is as to which of the two accused persons killed the two boys. Keval Singh and Outer Singh. Zagir Singh said in his confession that Balbir Singh killed the two boys, though Jagir Singh brought the kirpan. Balbir Singh, on the contrary, said that Jagir Singh killed the two boys. The benefit of this difference between the two confessions has been given to the accused persons by the learned judges of the High Court. There are differences with regard to some other points also, namely, whether the two accused persons remain standing inside the house for 15 minutes, whether Balbir Singh went to call Jagir Singh or Jagir Singh himself came to the house of Balbir Singh, whether all the ornaments were made over to the Jagir Singh, and whether the chadar was laid by Balbir Singh or by Jagir Singh at the spot. The difference with regard to the first 2 points mentioned above are, in our opinion, immaterial, as they have very little bearing on the commission of the crime. As to points 3 and 4, there is other evidence on the record. It showed that the gold earrings were taken by the appellant and the silver ornaments by Jagir Singh, and the chadar belonged to undoubtedly to the appellant. Assuming, however, that Mr. Sethi is right in his submission that the two confessions cannot be dissected in the way in which they have been done by the learned judge of the High Court, we do not think that such a submission advances the case of the appellant any further. So far as the confessional statement of Jagir Singh is concerned, it may be taken into consideration against the appellant if it fulfills the conditions laid down in section 13 of the Evidence Act. One of the conditions is that the confession must implicate the maker substantially to the same extent as the other accused person against whom it is sought to be taken into consideration. On the reading Jagir Singh's confession as a whole, it appears that he was really trying to throw the main blame on the appellant. Though he admitted that he entered into the house of Mr. Chinti, brought out a kirpan lying there, and took out some silver ornaments from that house. He denied that he had anything to do with the murder of Mr. Chinti or even the murder of the two boys. He more or less tried to make out that he was an unwilling spectator of crime committed by the appellant. In these circumstances, the utmost that can be submitted on behalf of the appellant is that the confession of Jagir Singh should not be used at all against the appellant. At one stage of this argument, Mr. Sethi did submit that the confession of Jagir Singh should be excluded altogether from consideration against the appellant later. However, he submitted that both the confessions should be read together in order to condemn both and untrue on the ground of the differences between the two confessions. We are unable to accept the submission of Mr. Sethi. We have pointed out that some of the differences are immaterial, some are due to the desire of Jagir Singh to throw the blame on the appellant, a circumstance of which the benefit has been given to the appellant, and some are differences are clearly resolved by other evidence on the record. We do not think that in these circumstances the confession statement can be condemned out of hand or in limine as untrue. In this case, both her confessions were retracted subsequently, and the proper approach in case of this nature is to consider its confession as a whole on its merits and use it again and make her thereof, provided the court in a position to come to an unhesitating conclusion that the confession was voluntary and true, and though a retracted confession, it believed to be true and voluntary made from the basis of conviction. The rule of practice and prudence requires that it should be corroborated by independent evidence. It is unnecessary to consider in this case if the evidence of an accomplice stand on a better, equal, or worse footing than retracted confession, nor need we consider the question of the nature and extent of corroboration necessary for the evidence of an accomplice. In this case, the main points for considerations were whether the confession of the appellant is voluntary, where it was true, and what independent corroboration was furnished by the other evidence on the record. We proceed therefore to consider the finding of the High Court from the aforesaid points of view. The learned judge of this High Court accepted the confession of the appellant as voluntarily made and substantially true. Nothing has been stated before us which should show that the High Court was wrong in accepting the evidence of the magistrate who recorded the confession, nor has it been pointed out that any rule relating to the recording of confession was violated. It appears that the appellant was produced before the magistrate at about 3 p.m. So this criteria were there, Your Lordship, on 22nd January 1954, and he was given time till about 4:15 p.m. To think over the matter, he was given again time till 5 p.m. And then after the necessary caution and questioning, his confession was recorded at about 5 p.m. When examined under Section 340 of Criminal Procedure Code, the appellant said that he was beaten, his father was maltreated, and that he was given something in tea which made him unconscious. The learned judges of the High Court rightly pointed out that no attempt was made to prove or substantiate these suggestions. They further pointed out that there was no time for the police to extract the confession statement from the appellant, and on the question of voluntary nature of the confession, the learned judge said that they had no hesitation in rejecting the defense plea that the confession was not voluntary. We see no reason to holding that finding the High Court is in any way vitiated.
Now the question is,
My lord.
judicial confession recorded under section 164 is not a substantive piece of evidence because the other side had no occasion to cross-examine. So it has to be used as a evidence of corroboration. That is why in paragraph 15,
My lord.
two things are to be required, two tests. One is voluntary and the second is truthful. Now, for the purpose of truthful, whether it is true, it has to be compared
Just
with other.
Yes.
Then, thereafter, it can be accepted as voluntary and true. So, second test is truthfulness. It has to be compared with other evidence. Standing alone,
My lord.
it cannot result in a conviction. Let's see. So, what other evidence?
My lord.
Now, what are the substantive evidence here? This is the
My lord.
first question.
My lord.
What are the substantive evidence?
Lordship,
Because see the Learned Trial Court
my lord.
and also prosecution perhaps, paragraph 53. Paragraph 53. These are the 7 circumstances.
My lord.
Page 83.
My lord.
Immediately before the occurrence, all the accused, including the deceased, were sleeping in the same room. Same thing.
Right.
2. Before committing the crime, the quarrel broke out between the deceased and the accused, Birendas, on question of money. Now, where is the substantive evidence on these 2 points? Because first one appears to be last seen together.
Last seen together.
No, first 3.
Yes,
see,
yes.
Who has said?
Our prosecution witness.
Your prosecution case, immediately before the occurrence, all the accused, including the deceased, were sleeping in the same room.
Yes.
Same room. But when? This is to be established as a fact.
Yes, my lord.
So it appears to be a last seen.
My lord.
Now, last seen,
There is no substantive evidence to that effect. As regards last seen,
last
it
seen,
has been discharged from the 164 statement of the.
164 will it
It will
come as a
visible
corroborative.
corroboration.
Leave aside.
Yes, my lord,
The procedure is to first see the substantive evidence, then thereafter,
lordship,
whether this corroborative evidence can supplement
my lord,
this 164
My lord.
statement. You leave aside 164 out of purview
My
right now.
my lord,
Now, what are the substantive evidence? Right? So, for circumstance one,
my lord,
that is close to classing.
my lord,
There is no substantive evidence.
My lord.
Somebody said they were sleeping together. But question is, last seen together is to be with the date.
dead. And there
Now-
has to be
now-
narrow,
Now come to doctor's evidence,
PW6.
PW6. Did he say in the postmortem report or in his testimony that the approximate time of death was 14-15 days? He did not say anything regarding decomposition of the body.
No.
PW
PW6
6.
doesn't say anything.
Leave
Let
to
us see the,
this will come.
my lord,
This can be taken as a circumstance
lordship,
in a case of resting on circumstantial evidence when they were last seen together,
lordship,
close in proximity of time to the
Right.
date. Right. Now, where this doctor say that approximate time of date was 14-15 days.
nothing. The PM report also I have seen,
PM report, see PM
Nothing.
report.
lordship, at page 100. This one, no? Time since date.
Then again, circumstance two, before committing the crime, quarrel broke out between the deceased and the accused Birendas on question of money. Where is the substantive evidence?
Nothing.
Then circumstance three, but the victim disappeared since 8/11/2016. From the date when quarrel broke out, where is that evidence?
That is not there, but victim disappeared since 8/11/16. Lordship,
But date of date,
date of death,
nothing.
nothing.
Prosecution has not led any
lord.
evidence. Yes, date was also, say, by medical evidence, that approximate time
Time
and
since the
of date is
mentioned here.
12-15
My lord.
days. That is not there. There is not even an iota of evidence that the body was decomposed. 12-13 days, body would have been decomposed. I don't know whether that septic tank has that particular acid to preserve the body
Lordship.
without decomposition.
Right.
I don't know if that has the chemical characteristic
Yes.
to preserve the body
Right.
for 10-15 days. In morgue, I think there are facilities to
Yes.
preserve the body,
Yes.
but septic tank, I don't know. So decomposition, he has not recorded anything. He did not say anything. So immediately before the occurrence, how this piece of evidence can be accepted? Am I clear?
Lordship, nothing. Inquest report is in it. Inquest report is in page. Inquest night, inquest report, was the page 95.
And fourth condition,
My lord,
fourth circumstance, dead body was recovered from the septic tank of the house near a construction place at the instance of Birendas. Okay, we accept. Accept for a moment. Not because 27,
my lord,
because on that date, he also pointed out again. But
lordship,
that was pointed out already by informant.
informant, lordship,
Then next part, the weapon was also recovered by the investigating officer at the instance of the accused Birendas. Where is that evidence? Yes, anybody said?
EM report also says rigor mortis is absent. So rigor mortis.
so
No,
after-
rigor mortis, there are stages.
Stage.
One normal, again rigor mortis, again non-rigor
Back to
mortis.
open.
So it was third stage.
Mm.
You would have been the best position to say approximate time of death, the doctor. Prosecution choose not to extract it out of the autopsy doctor. What can we do? So where is that the weapon was also recovered by the investigating officer at the instance of the accused.
Lordship, let us see the evidence of the.
No, he himself says,
Right.
but somebody has to corroborate it. We do not disbelieve otherwise. Because 164, Exhibit 6
I don't.
does not say so. He said, I forgot where I threw the Siprang.
But page 29. I recovered and seized the Siprang as shown by the accused Biren from a ditch near the septic tank, but the dead body of Goranga was concealed in presence of witnesses.
But nobody said witness. Find out from the prosecution witnesses. Who are your witnesses?
My lord,
All witnesses you have called.
my lord.
These are your witnesses, IO's witnesses. They are not from the public. Somebody was in a market, IO called. Somebody was in business, in his shop, IO called.
23 witness. Kasim Ali,
Planted perhaps.
maybe.
And they deposed wrongly about the date also.
The view.
মাতিছে তোমাকে আগে মাতিছে অ কিন্তু হেৰিছে সেইটো ব্যৱহাৰ কৰিছে
Lordship,
Mm.
PW4,
PW4, let us see.
8, 10, and 11.
PW4. PW4. Let us see. Which one?
PW4, Abul Bhuyan.
Page 12.
What did he say?
I know the accused Biren from the date of incident. Before 1 year ago, the occurrence took place. On the day of occurrence, police called me over phone and asked me to come to Munsisuba water tank. I went to that place. I saw many people gathered. I saw accused Biren Das was arrested by police. On being asked, the local people told me that one person was murdered and is
Not
accused-
admissible.
No. Biren Das has shown the place. Then the other part may be admissible, my lord.
Has shown the place where the dead
Where
body
the
was
dead
concealed.
body
Okay.
was
Okay.
concealed. The sweeper opened the safety room where the dead body was found. The magistrate are also present. On being asked by police, the accused confessed that he killed the deceased.
This part will not be
And
admissible.
police seized the sabul in my presence.
In my presence, at the instance of the accused, it was absent.
Then see the
Next one. Okay.
PW8.
Okay.
Page 70. I know the essence. I do not know the informant. Disease was also not known to me. Incident occurred 2 years ago. At a material time, one day at around 9:30 a.m., I went to have a cup of tea at Uttar Khalikola Center. At that moment, the officer in charge of
I have called. I have called.
Yes.
He is gathering witnesses.
On behalf of the-
Did he say about Sabul? No.
Then PW10.
8 also. PW8 in cross also. He did not say anything. Then
Then PW 10.
9, nothing.
10, madam.
10. No. No.
Thing, madam.
No.
11.
So where from this observation?
Lordship, I'll be relying on
Ah,
section 8 of evidence.
Only that much. That circumstance 4,
Lordship.
only one part, first part, second part cannot be. That weapon, Sabul was also recovered by the investigating officer. It should stop there. Not at the instance. At the instance of the accused behind us. No, this cannot be accepted. Then comes circumstance 5.
It was like
Accused
extradition
Virendas
conviction.
confessed his guilt in presence of large number of people gathered at the time of recovery of the body. So,
BW 1, 2,
but question is, yes, question is he was under arrest. He was under arrest,
Yes.
handcuffed. So, it should be before the magistrate. And magistrate has to depose, not the public. Where is the magistrate? Are there?
also
Hit by 26. He gave extrajudicial confession before police as well as before general public, including village headmen. This part gone. Now comes circumstance 6. 2 part to it. Bapan Datta. Okay, we'll leave it for the time being. Co-accused Umesh Deka. His judicial confession was not exhibited and also cannot be, even if it is treated as a 161, also cannot be treated as a dying declaration. This is gone. Only thing, Bapan Datta. Bapan Datta judicial
parts?
confession into 2 parts. If we dissect it,
I know.
first part goes. First
First
part
part-
goes regarding murder.
Yes.
I am innocent. He is the murderer. That part goes. The other parts,
Implicating himself.
this standing alone, this cannot be used as evidence. It has to be corroborative to something.
That is some.
Where is the substantive evidence? This is not substantive evidence.
But Lordship.
If we dissect these circumstances, only thing is that 8, section 8,
Section 8, yes.
section 8, what does it suggest?
My lord.
That even if 27 goes, it may be relevant.
Relevant.
And that only gives impression that he knows the place where the body was dumped.
Yes.
Nothing more than that.
Yes.
So, if section 8 is taken, he knows, A1 knows where the body was dumped. Now, there will arise 2 situations. That either he dumped the body or he had seen somebody dumping the body.
My lord. Yes.
That has been interpreted by the Honorable Supreme Court that from section 8, only relevant fact that will emerge is that he knew the place where the dead body was dumped. Right. Now, from there, 2 inferences are possible. One, he himself dumped the body there, or somebody else dumped the body. He had seen that somebody else dumping the body. Now, with that piece of evidence, plus this confessional statement part, whether this is sufficient to hold the A1, not to speak of A2 and A3. A3 is gone.
A2.
Whether A2 is, even if we treat that 201
Lordship.
offense,
My lord.
he has admitted, but that has to be used only as a corroborative piece of evidence to the substantive evidence. That is not there.
Nothing.
I don't think.
But your lordship, the circumstances whether your lordship will consider the circumstances.
Which one? Yes, I'm saying time
That
and
will come
again,
from the
section
again,
8.
164 statement. only,
Section
the
8.
Lordship,
So first you have to treat the case without the judicial confession.
my lord.
You have to see the substantive evidence. So these circumstances, I don't think this paragraph 53 are sufficiently established. This is the problem.
One citation on, 2005 7 is 7 on section 8, my lord. Para 9.
Around 9.
By virtue of section 8 of the Evidence Act, the conduct of the accused person is relevant if such conduct influences or is influenced by any fact in issue or relevant fact. The evidence of the circumstance simpliciter that the accused pointed out to the police officer the place where the dead body of the kidnapped boy was found, and on their pointing out the body was exhumed, would be admissible as conduct under section 8, irrespective of the fact whether the statement made by the accused contemporaneously with or antecedent to such conduct falls within the purview of section 27 or not, as held by this court in Prakash Chand versus State Delhi Administration. Even if we hold that the disclosure statement made by the accused appellants and is not admissible in the section 27 of the Evidence Act, still it is relevant under section 8.
Hmm.
The evidence of the investigating officer and PW 127 and PW 4, the spot Mahazar witness that the accused had taken them to the spot and pointed out the place where the dead body was buried is an admissible piece of evidence.
Yes, no doubt. I have been pointing out
Lordship,
repeatedly,
my lord.
this piece of evidence is acceptable.
Yes.
But the question is, just because he's shown the place, that is irrelevant, but that has to be other
Other
circumstances.
circumstances.
Now, from this, it shows, that is what I said,
My lord.
two things are possible. One, he himself dumped the body, or he had seen somebody dumping the body there. That is what the Supreme Court says.
Lordship, the probability.
I'm not saying. I'm not saying. I'm not saying.
My lord. Lordship, probably that Perry
So,
lordship
then-
will come up under section 34. He can be brought in.
Huh?
Section 34 because it
Where
was
is the
under-
section 34 will come in first? First,
Because
it
the
has to be
place,
established
whether
at least A2 is culpable.
whether he thrown the dead body or somebody else has thrown it, but it was within his absolute knowledge, my lord. Citation of it.
Hmm.
This practice is bad, huh? This citation to put it as paragraph. What? So he's all not if you go to
Sahaja. Sahaja. His statement is, I'll show you the weapon concealed adjacent to the shoe shop at Parley. This statement does not suggest that the appellant indicated anything about his involvement in the concealment of the weapon. Mere discovery cannot be interpreted as sufficient to infer authorship of concealment by the person who discovered the weapon. He could have derived knowledge of the existence of that weapon at that place through some other source also. He might have even seen somebody concealing the weapon, therefore it cannot be presumed or inferred that because a person discovered the weapon, he was the person who had concealed it. At least it can be presumed that he used it. Therefore, even if discovery by the appellant is accepted, what emerges from the substantive evidence as regards discovery open is that appellant disclosed that he would show the weapon used in the commission of the offense. So that much. He had the knowledge of the place where the dead body is dumped. But that does not mean that he was the perpetrator of the crime. There emerges two situations. One, either he had dumped the body, or somebody else dumped the body, he had seen it, or thirdly, he had known from somebody. Umesh Deka already disclosed before even the informant knows. At the time of lodging the fire, it was in a septic tank near his contract workplace. So, when two views are possible,
Nothing, no substantive evidence here, your lordship, in the case in hand.
Para 49 and 50 speaks about conduct, my lord. And the
conduct, that is 8, section 8,
Section 8 also referred there, in para 50 that.
that I have been saying it. That prosecution evidence is only relevant from the standpoint of section 8, nothing else. But that is only that he knew the place where a dead body was dumped. That is not from 27.
Right.
That is from only these witnesses who were called by the IO to the place. Because it was known to everybody that it was dumped. So that is itself is suspicious.
Right.
Section 8 evidence is also suspicious because everybody knew by that time. It was not a secret.
Lordship.
No, we are learning.
Lordship, everybody is learning. It's a process.
Okay. Okay. Next is not PW 15. Huh? I don't know. Doctor Kupurilam. As the case of the prosecution,
Another acquittal. In the instant is nothing here, lordship.
when we see side by side all the evidences, we have to go by the case principles, propositions for a case resting on circumstantial evidence. All the
Circumstances which goes against the prosecution.
Umesh
My lord.
might have killed, dumped the body, then went to the informant and said that these two persons killed.
My lord.
It might happen. Everything has to be with certainty now. That is the situation.
Here, 17 witnesses, no quality.
No quality. Ultimately, at the first look, yes, everything is correct. The
Sure.
body is recovered at his instance, so and so, confessional statement, such a strong case for prosecution.
My lord.
It looks like the case of the prosecution was that the dead body of the deceased was recovered from a place shown by the accused, comma, মই A1 বুলি কম পিছত আপুনি নামটো লিখি দিব A1 and the death of the deceased was a cause of death of the deceased was a homicidal one. In such view of the matter, comma, we now turn to the testimony of turn to the medical evidence available on record, which are in the forms of the testimony of the autopsy doctor, comma, PW6, and the postmortem examination report, PME report, Exhibit 4. Post-op. Subpara. PW6, comma, Dr. Orindam Bora, who, comma, on 21/11/2016, comma, was serving as the medical and health officer at Udalguri Civil Hospital, comma, performed postmortem examination on the dead body of Gaurango Nath in connection with Paneri Police Station case number 75 of 2016 and identified by UBC Rubul Ali, comma, Okhil De and Dudhon Das, page 14. A postmortem put us in. Postmortem page. In his testimony, comma, PW6 stated that after performing autopsy, comma, he found the following on the dead body of the deceased, page 14, A2, A. In the, he exhibited the postmortem examination PME report as EXT1, with his signature therein as EXT41. Full stop. In the PME report, EXT4, comma, PW6 recorded his opinion as regards the date full stop. He opined that the death was due to shock and hemorrhage due to penetrating injury on the forehead. And the injury sustained by the disease was sufficient to cause his death, instantaneously. Full stop. For ready reference, next paragraph. For ready reference, comma, the relevant parts of the PMA report EXT4 are also extracted herein below. Page 100 of start into 101 or record of some. All of record was hello. Delegate. Delegate below. The ideal, 105. Huh? Para. In view of the above medical evidence, comma, it can be considered. It can be safely concluded that the date of the disease was a homicidal one. Full stop. As to how the investigation of the case proceeded after the information FIR was lodged. Reference can be made to the testimony of the IO, province under Reka, PW 15, who testified about the sequence of events from the stage of lodgement of the institution of the affair to the submission of the charge sheet. Dosto. Para. In his evidence in chief, PW 15, deposed to the effect that on 2011-2016, when he was posted as a sub-inspector of police at Paneri police station, PW1, Ajoy Deka, lodged an affair with the officer in charge of the police station. Full stop. On the basis of the said affair, the officer in charge, Paneri police station, registered a case, Paneri police station case number 75/2016, page 28 of the same, under sections 302/201/34, IPC, and entrusted the investigation of the case to him. Full stop. The informant, PW1, informant, Ajoydeka PW1, at the time of lodging the affair at the police station, also brought the two accused persons, EIJ, Biren alias Bira, A1, and Umesh Deka, A3, and stated that Biren alias Bira, A1, committed the murder of Gauranga, and Umesh Deka, A3, informed him about the incident. Full stop. The statement of the informant, PW1 was thereafter recorded under section 161 CRPC in the police station. The statements of the two accused persons, Biren A1 and A3, were also recorded, and they were all taken into custody at night. of 2011-2016. Full stop. PW 15 further stated that A1 confessed in his statement that on 8/11/2016, at about 10:30 p.m., he committed the murder of Gaurango Das while he was sleeping by assaulting him within bracket Gaurango Das by means of an iron siprang within bracket an instrument used for digging earth, and with the help of Bapon Dotto A2 and Umesh Deka A3, who worked with him as masons. Full stop. PW 15 further stated that A1 disclosed to him that the dead body, was kept concealed inside a septic tank. Full stop. After such disclosure, the officer in charge Paneri Police Station discussed the matter with the additional deputy commissioner in order to recover the dead body as per the statement of A1. Full stop. It was on the following day, the PW 15 further stated that it was on the following day, that is 21/11/2016, he, along with the additional deputy commissioner, officer in charge, Paneri Police Station, Fulkumari Das, PW 12, the wife of the deceased, and police staff, on being led by A1, went to the place of occurrence, and A1, told before the public gathered near the place of occurrence that he concealed the dead body of Gaurango Das after assaulting him with his chiprang. Within bracket, chiprang, inside the septic tank. Poster. PW further deposed that on being shown by the accused A1, the dead body of the deceased was recovered from a septic tank in presence of witnesses. Full stop. PW 15 stated to have recorded the statements of witnesses, Umar Ali, PW 2, Tazan Ali Ahmed, PW 3, Abdul Bhuiya, PW 4, and Khabiruddin Ali, PW 8, before whom the accused confessed that he had committed murder of the deceased and thereafter, kept concealed in the septic tank. Kept the dead body concealed in the septic tank. Full stop. PW 15 further stated that after recovery of the dead body, the same was identified by the wife of the deceased. Fulkumari Das, PW 12.
Fulkumari.
PW 12. At the spot. Then, he, within bracket IO, recorded the statements of other witnesses. Full stop. Inquest proceeding was held on the dead body of the deceased by the additional deputy commissioner, Dithokananda Hazarika. Full stop. After the inquest, the dead body was sent to Udalguri Civil Hospital for post-mortem examination. Full stop. The IO stated to have prepared a sketch map of the PO. Full stop. PW 15 further testified that on the basis of the statements of A1 and A3, he arrested the accused, A2, who assisted them in concealing the dead body of Gauranga Das. PW 15 further stated that he recovered and seized the Siprang, as shown by the accused, A1 from a ditch, DITCH, ditch near the septic tank, where the dead body of Gauranga was concealed in presence of witnesses. He, IO, thereafter sent A1, A2, and A3 for recording their statements under Section 164 CRPC. And they were also produced before the court. PW 15 further stated that he collected the post-mortem examination report and after conclusion of investigation, finding a privacy case against the three accused persons, A1, A2, and A3, laid the charge sheet for the offences under section 301, 302, stroke 201, stroke 34, IPC. Full stop. PW 15 exhibit the IO, PW 15 exhibited the seizure list, whereby the iron Siprang was seized, as EXT 2, semicolon, the sketch map of the PO as EXT 5, semicolon, the statement of A1 recorded under section A1. Okay. The statement of the accused A1 recorded under section 161 CRPC as EXT 6 and his note as to recovery of the dead body as EXT 7 and the charge sheet as EXT 8. Full stop. The IO PW 15 also proved his signatures in the aforementioned exhibits. Full stop. Para. During cross-examination, PW 15 stated that the affair was lodged on 2011-2016 and the accused, A2 was arrested at 8 a.m. on 22/11/2016. Full stop. Prior to the arrest of A2, the accused A1 was arrested at about 6 p.m. on 2011-2016. Full stop. PW, he further stated that he did not record any declaratory statement of the accused persons apart from their statements under section 161 CRPC. Full stop. PW 15 further disclosed that it was accused A1 who mentioned the date of occurrence as 8/11/2016. Full stop. PW 15 admitted that the accused was in police custody at the time of leading to discovery of the dead body. Full stop. PW 15 denied a suggestion that he did not recover and seize the materials as indicated in the statement of the accused. Full stop. Right. From the evidence laid through by the prosecution through the above prosecution witnesses and the documentary evidence mentioned above, it has emerged that the FIR was lodged by the informant PW1 on 2011-2016, and at the time of lodging the FIR, the informant PW1 also brought the two accused persons, A1 and A3, along with him. Full stop. After registration of the FIR as Paneri Police Station case number 75/2016, the two accused persons, A1 and the movement, two accused persons, A1 and A3, were taken into custody. Full stop. It was on the following day, that is, on 21/11/2016, the IO along with the accused, with the additional deputy commissioner of the district, the officer in charge, Paneri Police Station, wife and the wife of the deceased, along with his staff, proceeded to a place at and recovered the dead body of the deceased from a septic tank there, septic tank there, full stop. The IO had claimed that the septic tank wherefrom the dead body was recovered, was sold by the accused, A1. Full stop. It has not emerged from the testimony of PW15 that the accused, A3, also accompanied A1 to the place of occurrence. Full stop. When the dead body was recovered on 21/11/2016, comma, the other accused, comma, A2, was not arrested, as he was arrested only on 22/11/2016. ঠিক আছে। কুর্তিটা হল ইনফরমেট হল Who are the witnesses who were called by the OC? The prosecution witnesses, comma, PW2, Umar Ali. Semicolon দিয়ে যাব। PW3, comma, Tajar Ali Ahmed. Comma, PW4, Abul Bhuiya. PW8, Khobiruddin Ali. Had all testified that they were called by the officer in charge, Paneri Police Station, or by police personnel to reach a place. They were called over phone to reach a place at Munsi Bosti.
My lord, these are PW 2, 3, 4, 8, and 13.
13. 13. 13 লিখব রে, PW 13 নাম হল মদন দাস।
Yes, ma'am.
No, he was to the police station, mister.
Yes.
No, read properly.
Yes, my lord. I'm sorry. PW
Niligo,
2,
niligo.
3, 4, and 8, my lord.
I have said already. According to PW2 and PW3, they were called on 20/11/2016 to Munsibari. First off, PW four and PW8 did not mention the date when they were called to Munsibari. Full stop. In their testimonies, PW2, PW3, PW4, and PW8. Have had deposed that when at the place at Munsibari, there was a gathering. Full stop. They admitted about the presence of the additional deputy commissioner, D. Hazarika, the officer in charge, Paneri Police Station, and other police officials. Full stop. PW2 deposed that the dead body was recovered on being shown by the accused, A1. When A1 was asked, he stated that he had monetary transaction with the disease, Gauranga, and for that reason he had killed Gaurango, and other accused persons assisted him in killing the deceased and to keep the dead body, to conceal the dead body in the septic tank. It was separate for you. PW3. Stated that at the spot local people, the local persons told him that the accused person killed one Gaurango Das and concealed his dead body in the septic tank. Thereafter, police asked the accused to show the dead body, and the accused led police to a septic tank. Thus, a sweeper then opened the septic tank and found the dead body of the deceased. PW3 further stated that when asked, the accused, A1 confessed that he had killed the deceased with the help of two other persons. PW4, Abul Huiya. Like PW3, deposed that at the place, when he went to the place at Munsibari, local persons told him that one person was murdered and his dead body was concealed in a septic tank. Full stop. Then the accused, A1, showed the place where the dead body was concealed and A sweeper, called by police, opened the septic tank where the dead body was found. Full stop. PW 4 further stated that when asked by police, the accused, A1, confessed that he had killed the deceased with a sabul, within bracket iron rod. Full stop. PW 4 stated that the sabul, iron rod, was seized by police in his presence wide by a seizure list, EXT2, and he gave his signature therein as EXT21. Full stop. PW8. Eight. Khabiruddin Ali. Deposed that after the call received from the officer in charge Paneri police station, he proceeded to Munsibari. Full stop. There, the officer in charge Paneri police station told him that a dead body was found inside a septic tank. As shown by the accused, A1. Who's the PW8 stated that he saw the accused, A1 in handcuff. And the accused, A1, when asked, confessed before them that he committed the murder of the deceased and thereafter, kept the dead body inside the septic tank. Full stop. PW8 also stated that police recovered and seized one Siprang in his presence via the seizure list EXT2, where he gave his signature as EXT22. Full stop. Let us separate. In their cross-examination, all these witnesses, PW2, PW3, PW4, and PW8 admitted that they did not have any personal knowledge as to how the incident took place. What else emerged from the testimony of the aforementioned prosecution witnesses PW2, PW3, PW4, and PW8 is that on being called by the police personnel, they went to a place at Munsibari. Post of going there, they saw the accused person, A1 in handcuff. That is, handcuff. And there was presence of the additional deputy commissioner, officer in charge Paneri police station, and Paneri police station, along with other police personnel. Post of. These prosecution witnesses had claimed that the dead body of the deceased Gauranga was recovered from a septic tank. After the septic tank being shown by the accused, A1. full stop. In their depositions, comma, they had also stated that when the accused was asked by police, comma, the accused A1 admitted that he had killed the deceased and thereafter, comma, concealed the deceased, comma, Gauranga Das, and thereafter, comma, concealed with the help of a iron object, comma, called differently as
One iron
Siprang,
Siprang length about 3
Ah.
feet.
Siprang, comma, Sabul, iron,
Conti.
Conti, etc. And thereafter, conceal the dead body of the deceased in the septic tank with the assistance of two other accused persons. Assistance of the other two accused persons. Remember us. PW5, Radhesham Dotto
PDP.
was a person who was present at the place where from PW5 stated that he went to the place. PW5 was a PDP secretary of village number 1 Geruajhar, and in his deposition, comma, he stated that he the inquest proceeding in the after the inquest proceeding, comma, after the inquest proceeding, comma, conducted by the magistrate, comma, he subscribed his signature in the inquest report EXT3 as EXT31. This witness was not cross-examined by the defense. So PW7, comma, Sahib Khan testified to the effect that when on one day he in 2016 he heard that a dead body was recovered from a septic tank at Munsibari, and a large number of people gathered there, comma, he went there and noticed that one dead body was removed from a septic tank in presence of police personnel and the SDO civil. Police personnel, comma, the SDO civil and comma, village headman, PDB secretary, etc. Full stop. The inquest proceeding was conducted by the civil SDO, and he, within bracket PW7, gave his signature in the inquest report EXT3 as EXT31. 8 হয়ে গেল। PW8, হয়ে গেছে। কি করব? PW9 সাদেক আলী, এটা সাদেক আলী, PW10 কাসেম আলী, and PW11 Salim Ali are all inhabitants of village Uttar Kalikhola. So PW9 deposed that he knew the informant, the deceased and the accused persons. So he stated that the deceased Gauranga Das used to work with the deceased Gauranga Das, a mason, used to work with the accused persons. Pusto. Mentioning about a day, he stated that on that day, the accused and the deceased, the accused persons and the deceased, after finishing their works, they went together. It was after 15 days, he came to know that a dead body was recovered from a septic tank at Munsi Bosti. And he went there to see the dead body. So going there, he saw that many persons had gathered there, including the officer in charge, Paneri police station, the SDO, village headman, and the VDP secretary. PW9 also further stated that the accused who was in handcuff, showed the place where from the dead body of Gauranga Das was recovered. Showed the septic tank. PW9 also stated that the accused A1 confessed before the people gathered there that he had committed the murder of Gauranga Das and thereafter, concealed the dead body in the septic tank. Also. In cross-examination, PW9 denies the suggestions given to him by the defense. We'll come back. কিন্তু চলি আছিল নেকি টেনটো চলি আছিল নে পিডব্লিউ 9, 10 আৰু 11 একেলগে গৈছিল ন PW10 কাছেম আলী knew the accused persons as they were working in a house, no, working near his house. Full stop. Middleton stated that the accused persons and the disease from a Gorangodas were masons by profession, and they used to work under a contractor, Ajoy Deka PW1, who is the informant of the who was Ajoy Deka PW1. Full stop. Deposing as regards an incident in 2016, PW 10 stated that at the material time, the deceased and the accused persons were engaged by the informant PW1 contractor for doing some masonry work. After 15 days, he heard that a dead body was found inside a septic tank at Munsibari. On hearing the news, he went to Munsibari to see the dead body. Going there, he saw the presence of the SDO, officer in charge, Paneri Police Station, village headman, the VDP secretary, and other persons there. So he also saw the accused, A1 under handcuff. PW10 stated that on being led by the accused, A1, a dead body was recovered from a septic tank behind a house, and he identified the dead body of Gourango Das. The dead body was then recovered from the septic tank by police in his presence with the help of sweepers. Later on, the dead body was taken to the police station. PW10 also stated that police also recovered a chiprang in his presence, and he signed as a witness in the seizure list EXT2, and he identified his signature therein as EXT23. In cross-examination, he denied a suggestion that the police did not recover the dead body on being laid by the accused. He also denied a suggestion that the accused did not confess before them that he killed the deceased. He reiterated that once Siprang was recovered and seized by police at the place of occurrence. 11 only. PW11, Salim Ali. Knew the accused persons as masons by profession. He stated that at the material time, they were engaged in a contract work at Uttar Kalikhola. Deposing about the recovery of the dead body, he stated that one day in 2016, the VDP secretary called him to the site where the accused persons were parley walking. When he reached the place, he saw the presence of police personnel there, full stop. PW one stated that one Siprang was recovered by the public in that place, and the same was seized by police in his presence. Full stop. He stated that he signed as a witness in the seizure list EXT2. Full stop. He also identified the Siprang, when shown to him as Met EXT1, as the one which was seized by the seizure list EXT2. Full stop. In cross-examination, PW11 stated that the dead body was recovered prior to his visit to the place where from the same was recovered. Full stop. From the testimonies of the aforementioned three prosecution witnesses, PW9, PW10, and PW11. It has emerged that they used to know the disease and the accused persons as all of them were working at a place. All of them were engaged as masons in a contract work, undergoing at a place in their village. Full stop. From their testimonies, it has emerged that they used to know the disease and the accused persons as the disease and the accused persons were engaged in that contract work in their village. Full stop. They stated from their evidence, it has further emerged that a Siprang was recovered in their presence from the testimonies of PW10 and PW11. A Siprang was recovered in their presence and they signed as a seizure witness in the seizure list EXT2 prepared by the police in that connection. Full stop. There is discrepancy in the evidence of PW10 and PW11 as regards the date of seizure of the Siprang. Full stop. According to, but none has deposed as regards the exact date when the Siprang was recovered by police from the place of occurrence. Stop. Who is PW12? 12. Wife, no, wife. Okay, PW12. Pulkomai Das was the wife of the deceased. Full stop. PW12 was not an eyewitness to any of the events. No, BW 12. Deposed to the effect that her husband Gauranga Das was working under the informant, PW1, Ajoy Deka at the time of his death. Working as mentioned under such. PW12 further stated that the accused persons were also working along with her husband at the relevant point of time. Post. PW 12 further stated that on 21/11/2016, she was informed by the in charge Mohori, Okil De. She was told, she was not informed, told to Okil De to go to the place where her husband was working. So she was taken thereafter, to the police station. When her identity was known, when her identity as the wife of the deceased, Gauranga Das was known, she was taken by the police personnel to the place where her husband was working. Posto. Going there, she came to know that her husband was killed in that place. And saw his dead body there as the same was recovered from a septic tank. Posto. After she identified the dead body of her husband, she was taken. She was sent home. So she came to know at the place of occurrence that from the people gathered there that it was the accused A1 who committed the murder of her husband and thereafter kept the dead body concealed in the septic tank. In cross-examination, PW 12 stated that she did not know how her husband had died at the place of occurrence. And prior to that day, she never visited the worksite where the dead body of her husband was found. According to PW 12, her husband used to visit home from the worksite once in a week. So the accused persons prior to the incident, used to come along with her husband to their house now and then. Who is that? Oh, oh. PW 13, Modern Das, who knew the informant and the accused person, who knew the informant and the accused persons, was the brother, is the brother of the deceased Gauranga Das. PW 13 testified to the effect that on one day in 2016, he was informed, he was told by the police personnel from Paneri police station to visit the police station, full stop. He visited. Accordingly, he visited the police station at around 12 o'clock on that day. And after ensuring his identification, the police personnel there showed him a dead body for identification. The dead body showed him a dead body as the dead body of his brother, Gauranga Das. Full stop. PW 13 stated that the accused persons used to work with his brother, Gauranga Das, who was a mason by profession. And the accused person used to not like. In cross-examination, PW 13 stated that he did not know as to how the incident had occurred, resulting into the death of his brother. Right, Nikhil?
Yes, brother, my lord. PW 14 also brother.
PW 14, Sudhan Das is another brother of the deceased, Gauranga Das. Full stop. According to him, the occurrence took place on 8/11/2016. Full stop. It was on that day, on 8/11/2016, the informant, PW1, Ajoy Deka, informed him telephonically at about 9 a.m. that the accused persons who were working as masons along with his brother at Uttar Kalikhola, committed the murder of his brother during sleep, and the dead body of his brother was recovered from a septic tank. Full stop. On receiving the information, PW 14 stated, came to the police station and came to the Paneri police station and saw the dead body of his brother there. The dead body was thereafter taken to Udalguri Civil Hospital for post-mortem examination. And after post-mortem examination, the dead body was handed over to the family. Full stop. The prosecution witnesses PW 12, PW 13 and PW 14 were relatives of the deceased. So the PW 12 was the wife of the deceased, and PW 13 and 14 were the brothers of the deceased. None of these prosecution witnesses had knowledge as to how and as to when the deceased had made his death. Full stop. From the their testimonies, it has however emerged that the accused persons were known to the deceased as they, as masons, were also working at at Uttar, at the site, at the same site, at Uttar Kalikhali, under the informant PW1, Ajay Kumar Deka. Post of last. PW16, Dr. N.C. Bhuya was, on 23/11/2016, was posted as Munsif Judicial Magistrate, first class at Udalguri. Post of. As per his testimony, as per the testimony of PW16, he was directed by the Chief Judicial Magistrate of Udalguri on 23/11/2016 to record the confessional statement of the accused, A2. When A2 was produced before him on 23/11/2016, he appointed one legal aid counsel as the accused A2 was found not represented by any defense counsel. Post of. Thereafter, the accused A2 was explained that he was not bound to make any confession, and if he did so, it might be used as evidence against him. Post of. After explaining so, the accused, A2 was remanded to judicial custody for 1 day for reflection. Post of. Thereafter, the accused A2 was produced before him on 25/11/2016 from jail, and on that occasion also, A2 was explained that he was not bound to make confession, and if he did so, it might be used as evidence against him. Post of. When the accused A2 wanted to make confession, he was placed under the custody and supervision of a court peon from 10 a.m. to 3 p.m. for reflection. Post of. When at 3 p.m. on 25/11/2016, the accused, A2 was asked again as to whether he wanted to make confession or not. The accused answered in the affirmative. Even after explaining him that he was not bound to make confession. Post of. PW16 testified to the effect that after it was found that the accused, A2, still wanted to make confession voluntarily, he recorded his statement in his presence, and after recording the statement, the same was read over to him. Post of. When the statement was read over to him, the accused A2 admitted the statement as a correct one. Post of. PW16 testified that the confession contained a full and true account of the statement made by the accused A2, and at the time of recording, the accused was in a fit state of mind. Full stop. The signatures of the accused was thereafter taken in his presence. Not taking signature fatal. And after completion of the formalities, the accused was remanded to judicial custody. Full stop. PW 16 exhibited the orders passed on 23/11/2016 and on 25/11/2016 as EXT 9 and EXT 10 respectively, along with his signatures appearing therein. Full stop. PW 16 also exhibited the confessional statement of the accused A2 as Exhibit 11 and identified his signatures therein as EXT 11-1 and 11-2 respectively, EXT 11-2. PW 16 also identified the signatures of the accused A2 in EXT 11 as EXT 11-3, 11-4, 11-5, 11-6, 11-7, and 11-8 respectively. When cross-examined, PW 16 stated that when the accused, A2 was produced before him for recording confessional statement, he noticed some injuries on his person. Full stop. He further stated that accused on 25/11/2016, the accused, A2 was produced from judicial custody. Full stop. Fair enough. From the testimony of PW 16, Dr. N.C. Bhuya, it has emerged that PW 16 on 25/11/2016 recorded the confessional statement of the accused, A2 under section 164 CRPC. Full stop. The learned MECQ, plural, appearing for the appellants, have not made any submission, have not mounted any challenge as regards the procedure followed by PW 16 in recording the said confessional statement EXT 11 vis-a-vis the provisions contained in section 164 CRPC read with section 281 CRPC. So they have, however, contended regarding their challenge is on the point of admissibility of such confessional statement. From the standpoint of the rule contained in section 30 of the Evidence Act. First, para. The admittedly, comma, the present case is one. The present case is rested on circumstantial evidence. Full stop. The law the duty and role of the prosecution in a case resting on circumstantial evidence the obligation cast on the prosecution. Obligations have been succinctly explained by a three-judge decision in Sarda. Huh? In a Bidisan, so and so, 1976, 01 or 4. 76, 4 SCC, 4 116 perhaps. 116, para 153, 152, 153, and 154. Huh? Para. এই ভুল টেবুলখন আছে ভুল টেবুলখনত
Well, 84 4 SC
1,
116.
2, 3. Three judges. 1984, 4 SCC 116.
116.
Para
75.
152, 153, and 154. In the case in hand, comma, the prosecution has relied upon a number of circumstances to and has urged that if the circumstances are linked together, comma, the chain of circumstantial evidence is found to be complete. To bring home the charge of murder against all the three accused persons. Bring home not only the charge of murder under section 302, but also the charge under section 201 IPC in aid of section 34 IPC. First of the learned trial court to return the finding of guilt to arrive at the finding of guilt, comma, had delineated after referring to Sarad Vidir Sand Sarda Supra. Have delineated the circumstances in paragraph 53 of the judgment, which reads as under paragraph 53, page 82. Paragraph 53 and 54. 53 and
Yes,
54.
yes.
53 and 54. এই ডাঙৰ এভিডেন্সৰ কিতাপ before stop the learned State Council has urged that the recovery of the dead body of the deceased from a septic tank at a place in Munsibari and the recovery of the Chiprang MAT EXT1 were pursuant to the statement of the accused, A1 EXT6 and such recovery is admissible under Section 27 of the Evidence Act. Gusto. The prosecution has also stressed on the judicial confession of the accused, A2, EXT 16, 11, to submit that the same had corroborated the other evidence laid by the prosecution for both the charges. Also, the learned trial court had also is also found to have placed reliance upon the confession of the accused, A3, who had already expired during the trial, as a circumstance in the chain. Gusto. Para. Yes, evidence. Before a discussion on the substantive evidence, claimed to have led by the prosecution during trial, a reference to the rule of evidence contained in Section 30 Evidence Act appears necessary. Full stop. As per Section 30, bold থাকাটো দি দিব। Bold থাকাটো দি দিব। When more persons than one are being tried jointly for the same offense, and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as regards such other person as well as against the person who makes such confession. Stop. The full stop. Illustration A aptly brings out the rule. Full stop. Which aptly brings out the rule, reads as under illustration A. From rule 30, from a reading of rule 30, it is evident that before a statement by one of the accused persons can be taken into consideration against the other accused, the following conditions must be fulfilled. A, there must be a joint trial for the same offense, semicolon. 2, it must be a confession. And 3, and 3, not 3. The confession of guilt must affect himself and the other. That is, implicate the maker substantially to the same extent as the other co-accused. And 4, the confession of guilt must be duly proved. Full stop. It is settled law that a confession is to be used only to corroborate other substantive evidence led by the prosecution Full stop. A confession of a co-accused cannot be treated as substantive evidence, and it can be pressed into service only when the court is inclined to accept the other evidence and feels the necessity for to lend assurance to lend an assurance. Thus, a confessional statement of an co-accused per se is not substantive evidence against a co-accused. Full stop. Resting the discussion on the confessional statements of A2 and A1 at this stage, for the time being, we turn to the prosecution, other prosecution evidence, which are claimed to be substantive evidence. We come back. It will take Mr. Mondo. And many points are involved, we have to dictate. The prosecution. Appears to have relied on lasting together theory indirectly. সঞ্জয় ঠাকরান আছিল না সঞ্জয় ঠাকরান Sanjoy, এটা তো হল নয়। It is a restricted completion. It is a Sanjoy Thakra. Sanjoy Thakra. Nursing theory, Sanjoy Thakra. Nursing Mara, Sanjoy Thakran Thakran. Nursing Maile, Sanjoy Thakran. Huh? Hmm. Make it go. The prosecution has sought to project that the death of the deceased had occurred on 8/11/2016. Full stop. The said projection appears to have been based on the information given in the FIR EXT1 by the informant PW1, which information in turn, was based on information purportedly given to him by the accused, A3. Full stop. But none of the prosecution witnesses had specifically deposed to the fact that either on 8/11/2016 or on any date immediately preceding 8/11/2016 or succeeding 8/11/2016, the deceased was seen in the company of the either of the three accused persons. Full stop. Para. The Sanjay Thakran was, no, para 34. The circumstance of last seen together is normally taken into consideration for finding the accused guilty of the offense charged with when it is established by the prosecution that the time gap between the point of time when the accused and the deceased were found together alive and when the deceased was found dead is so small that the possibility of any other person being with the deceased could be completely ruled out. Full stop. The time gap between the accused persons seen in the company of the deceased and the detection of crime would be a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. But in all cases, in all cases, it cannot be said that the evidence of last seen together is to be rejected merely because the time gap between the accused persons and the deceased last seen together and the crime coming to light is after a considerable long duration. There can be no fixed or straitjacket formula for the duration of time gap in this regard, and it would depend upon the evidence laid by the prosecution to remove the possibility of any other person meeting the deceased in the intervening period. That is to say, if the prosecution is able to lead such evidence that likelihood of any person other than the accused, being the author of the crime, becomes impossible, then the evidence of circumstance of last seen together, although there is long duration of time, can be considered as one of the circumstances in the chain of circumstances to prove the guilt of such accused persons. But the circumstance of last seen together, State of Goa versus Sanjay Thakran, 2007, 3 SCC 755. But the circumstance of last seen together does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing. There must be something more to establishing connectivity between the accused and the crime. Full stop. Reverting back to the facts of the case. Again, when we turn to the testimony of the autopsy doctor, PW, six and the PMA report. It is found that the autopsy doctor did not depose anything regarding approximate time of death of the deceased, either in his testimony nor in the PME, did not depose or record. Did not depose or record. Either in his testimony or in the PME report as regards the approximate time of death of the deceased when he performed the autopsy on the dead body of the deceased on 21/11/2016. Full stop. There is, it did not, it has not, PME report to given.
Yes.
When we looked, when we have looked at the PME report EXT 11, page EXT 4, EXT 4. Yes, I love it. Is that what? The type code is going on? Activity. I hate to swan as well. There is, we find no mention that the body recovered, body recovered on 21/11/2016 was a decomposed one. Post op. It has, however, been reported that rigor mortis was absent. Full stop. In the absence of any medical evidence,
Lordship,
True that.
inquest, it has been mentioned in the inquest report, page 95.
what is the value of inquest report? He is not an expert. ADC cannot. ADC, how can ADC? Is it required to mention?
But
He is an ADC.
my lord,
He is not an expert.
he's not an expert, but it has been mentioned in inquest with decomposed insects found over the body.
Doctor is not finding it. What to do? It has no value inquest. Suspicious death to that extent. Unnatural death. Show me anything that regarding approximate date inquest can be relied upon. ADC performing inquest. Doctor should have.
In order to link, it's not there.
Full stop. Thus, we find that there is no credible evidence that no credible evidence either in the ocular evidence or in the medical evidence to reach a conclusion that in the ocular evidence that immediately before the occurrence, all the accused persons and the deceased were sleeping in the same room to bring in the theory of last seen together. Post op, there is no evidence, including medical evidence, that the deceased had died on 8/11/2016. Due to due to absence of any opinion as regards the approximate time of death of the deceased, either in the testimony of the autopsy doctor PW6 or in the PMA report. Full stop. In the same light, comma, the circumstance full stop, para. Second circumstance to comma, second circumstance to cover লাগিব. CRPC conjunction. Section 162 CRPC. Lays down a fundamental principle to be followed in a criminal trial, that a statement made before a police officer during investigation cannot be used for any purpose whatsoever, comma, except to contradict a witness in the manner provided by Section 145 of the Evidence Act, semicolon, and when any part of such statement is so used, comma, any part thereof in the cross-examination of such witness, comma, that too, comma, only for explaining any matter referred to in his cross-examination, full stop. Section 162 CRPC has, however, provided that such a statement can be used when it attracts, when it falls within the provisions of Clause 1 of Section 32 of the Evidence Act or to affect the provisions of Section 27 of the Evidence Act. Post. Evidence Act. As per Section 25 of the Evidence Act, a confession made to a police officer is prohibited and cannot be admitted in evidence. Post. Section 26 of the Evidence Act has provided that no confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Section 27 of the Evidence Act is an exception to Section 25 and Section 26 of the Evidence Act. So it makes that part of the statement which distinctly leads to discovery of a fact in consequence of information received from a person accused of an offense, quote unquote, accused of an offense, to the extent it distinctly relates to the fact thereby discovered, admissible in evidence against the accused. Full stop. The fact which is discovered as a consequence of the information given is admissible in evidence. Full stop. Further, the fact discovered must lead to recovery of a physical object, and only that information which distinctly relates to that discovery can be proved. Full stop. The fact discovered and the recovery. So the rationale behind Section 27 is that the fact discovered and the recovery is an assurance that the information given by a person accused of the offense can be relied. Subsection 27 of the Evidence Act does not, however, lay down a principle that discovery of a fact is to be equated to the object produced or found. Full stop. The discovery of the fact resulting in recovery of a physical object exhibits knowledge of the person accused of the offense as to the existence of the physical object at the particular place. Full stop. Accordingly, discovery of a fact includes the object found, comma, the place from which it was produced, and a knowledge of the accused as to its existence. Full stop. The first, no, the one of the leading case on section 27 is Pulukuri Kotaya versus Emperor, comma, reported in AIR 1947, Privy Council 67. Full stop. Expounding on the rule enshrined in section 27 of the Evidence Act, comma, in it has been observed in Pulukuri Kotaya as under paragraph 8, 9, and 10. Also 11 not paragraph দিয়া আছে dot দি dot দি এইখিনি ব্ৰেকেটত দিয়াটো 11 ৰ to bring the rule enshrined in Rule 27, comma, formal arrest is not a necessity. Full stop. The Therefore, comma, the expression quote unquote custody under section 27 of the Evidence Act does not mean formal custody. Full stop. The Constitution bench of the Honorable Supreme Court in State of Uttar Pradesh versus Teoman Upadhyay, comma, 1961, 1 SCR 14. Has observed that the bar under section 25 of the Evidence Act, no, the ban to be effective for section 25 and section 26. The person need not have been accused of an offense when he made the confession. Full stop. The expression, quote unquote, a person accused of any offense, unquote, in section 26 and 27. Would include a person who is under any kind of restriction, restraint or even surveillance by the police. Full stop. Even if the accused was not formally arrested at the time of giving information, the accused ought to be deemed, for all practical purposes, in the custody of the police. Full stop. As soon as an accused or suspected person comes into the hands of a police officer, he is no longer at liberty and he is under a check and is, therefore, in quote unquote custody within the meaning of section 25 to section 27 of the Evidence Act. Full stop. Going by the above proposition, we find that so far as the statement of the accused, A1 recorded by the IO, which was exhibited as EXC6, would come within the scope and ambit of section 27 of the Evidence Act, even though on 2011-2016, the accused A1 was not formally arrested, though he was, but after he was handed over, after he was brought to the police station by the informant PW1, the IO had taken him into custody. Full stop. It is to be borne in mind that as per the rule contained in section 27, only so much of information which relates distinctly to the facts thereby discovered can be stated to have been proved. Full stop. And it is only so much of the information as relates distinctly to the fact discovered thereby would be admissible in evidence. সিরিয়াস বস্তুটা ঘটিছে সিরিয়াস বস্তুটা ঘটিছে মানে when সিরিয়াস কথা ঘটিছে একটু ইট হব লাগিব নহলে মানে কোর্টত at this stage, comma, at this juncture, comma. If Venkatesh will judgment Venkatesh Marson. MS Bhuya, there is it needs to mention here, I feel that Supreme Court has said repeatedly that the entire statement should not be brought on record. Only that part which leads to discovery of the fact is to be brought on record, right? Here, Exhibit 6 was the entire statement where he described the story. And if that thing is brought on record, it tends to influence the court. Only that part should have been taken. Here he said the entire story. The other part is not admissible.
Oh, shit.
And it influences everybody. Mr. Tiwari, MS Bhuya, and the court also. How he murdered, how he killed Sabul and all.
My lord.
But Pulukuti says that he has the knowledge that because
Yes,
only that
yes,
fact,
yes.
only that part is admissible. The
Except
other
the
part
gray part.
should not be brought on record. So that is why I like to observe one particular thing.
I know.
At this juncture, comma, it is apt to refer to the following observations made in the decision in Venkatesh, Elias, Sondra, and another, etc. versus State of Karnataka, comma, reported in 2022 Live Law SC 387. It was piece of change corridor, Are para 19. Finds place in the court. Such kind of statement may have a direct tendency to influence and prejudice the mind of the court. This practice must necessarily stop, and in the present case of time, only except the entire statement. Full stop. Para 19 or huh? In the case in hand also, comma, the prosecution had brought the entire statement of the accused, comma, A1. Has brought question on record in the form of EXT 6. Full stop. Go to EXT 6 to excluding for a scene region, comma, we like to extract only the relevant parts of EXT 6 which have a bearing. Qua. Section 27. Evidence Act. The said the relevant part of EXT 6 would be as under. একটু হনি হুম 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 quote then we put Gauranga's is 109 but dead body into the septic tank and close the lid. Hmm? পিছত লাষ্টৰ ব্ৰেকেটত দি দিব from the exposition of the rule of evidence enshrined in Rule 27 of the Evidence Act in plethora of decisions, it emerges that the first condition imposed and necessary for bringing into operation the section into operation is the discovery of a fact which should be a relevant fact in consequence of information received from a person accused of an offense. Full stop. The second is that the discovery of such a fact must be deposed to. Full stop. To bolded rakhibo. Next to a fact already known to the police will fall foul and will not meet the condition. Full stop. The third is that at the time of receipt of the information, the accused must be in police custody. Full stop. Furthermore, it is only so much of the information which relates distinctly to the fact thereby discovered, resulting in recovery of a physical object which is admissible. Full stop. Rest of the information is to be excluded. Full stop. Only that part of the information which is clear, immediate, and a proximate cause of discovery is admissible. Full stop. The facts proved by the prosecution, particularly the admissible portion of the statement of the accused, would give rise to two alternative hypotheses, namely, firstly, that the accused had himself deposited the physical object which was recovered, or secondly, only the accused knew that the physical object was lying at that place. Full stop. The second hypothesis is incompatible with the second hypothesis is compatible with the innocence of the accused. Whereas the first hypothesis would be a factor to infer involvement of the accused in the crime. Full stop. Therefore, the court has to analyze which of the hypotheses is to be accepted in a particular case. Full stop. Hey, 106, you submitted on 106. As the prosecution. The prosecution hearing has projected that the rule of evidence contained in section 6 of the 106 of the Evidence Act is applicable in the case in hand. Full stop. Section, it is required to keep in mind, kept in mind. এই কিনাখন 101 ওপৰত কৈছিলো নহয় হা এইখিনি কৈ 101 টো ক'ব লাগিব কৈ পেলাই হা এইখিনি যে আছিল 101. It is to be kept in mind that as per section 101. তাৰপিছত 106 হা তাতে আছে. Thus, section 106 of the Evidence Act does not in any way dilute, does not in any way lessen the burden of proof, which is always on the prosecution. Full stop. Section 106 comes into play when the prosecution is able to establish the facts by way of circumstantial evidence. Full stop. The rules of evidence contained in 106 comes into operation only when the various links in the chain of evidence laid by the prosecution are found to have been satisfactorily proved and the circumstances point towards the guilt of the accused with reasonable definiteness. Full stop. Para. though the IO, PW 15 deposed to the effect that the dead body of the deceased was recovered from a septic tank at Munsi Bosti on 21/11/2016 on the basis of the statement of the accused person, comma, A1, comma, recorded as EXT 6, comma, when we find from on perusal, on reading, no? On reading, the purported confessional statement of the accused person A1, EXT 6, we find that you want to say? We find at the end of the said statement, we find the following statement at the end of the said statement, quote, 110, quote, I showed to the police the place where I had kept the dead body hidden, unquote. Full stop. From the aforequoted statement, comma, it is evidently clear that the statement was recorded after recovery of the dead body of the deceased from a septic tank at Munsi Bosti. Full stop. MS Mia, have you looked at the record?
Yes.
Any idea when's the statement?
Oh,
We did not find the statement.
statement of my love.
We did not find that statement in the case record.
Oh, exhibit 7 is not there, but
Exhibit-
exhibit 6 is there.
Exhibit
6, I have marked yellow color flag
Ah.
mark was there. I marked it yesterday. Orange.
Exhibit, this one is
Six.
there.
It's there.
Okay. See, let me see. Any date? Any date mentioned? Recorded? When it was recorded?
All orange, yes.
Orange.
Maybe take that. Exhibit 6.
On any date? No statement made by any person to the materials on record does not indicate as to when such statement, ext was recorded by the IO. Full stop. The place it is pertinent to mention that in the FIR, ext 1 the informant PW1 mentioned that he was informed by the accused, A3, that the two accused persons, A1 and A2, after killing the deceased, dumped the dead body of the deceased in a septic tank. Full stop. And all the accused persons and the deceased were engaged in construction of a water tank at Munsibosti in village Uttar Kalikhola. Full stop. Few of the prosecution witnesses like PW, who said 2011.
2011.
PW1.
No, we are on AW A2. It was A2.
A2, Bapon.
A1 statement was never,
Oh, wait. Gosh,
A1 was never,
yes,
it was A2.
A2 step. Lordship PW1, 2011. Occurrence took place on 2011.
On 2011, will here, on 2011, in the FIR lodged on sense.
PW2 also says so.
Thus, from the FIR, it is evident that the dead body was kept concealed in a septic tank. At Munsibari area in village Uttar Kalikholi was informed to the IO on 2011-2016 itself. Full stop. Under Section 27 of the Evidence Act, if an information given by the accused leads to the discovery of fact, which is the direct outcome of such information, then only it would be evidence. But when the fact has already been discovered, as in the instant case, the evidence could not be laid in respect in that connection. Full stop.
My lord, these are PW 1, 2, and 3. They set it on 20, 11, 16 on the date of occurrence. The body and the ship was taken.
Meaning thereby, if the dead body was already recovered by the police prior to recording of a confessional statement of the accused, then statement of the accused that he threw a from the from a septic tank in so and so, already recovered, Then the statement of the accused recorded subsequently as to where he concealed the dead body is not admissible under Section 27 of the Evidence Act. For the reason that a fact which has already been discovered, evidence could not be laid in that connection. Full stop. Thus, no value can be attached to the purported confessional statement exhibited by the prosecution as EXT6. Full stop. As this circumstance 2 was on the basis of EXT1 only, EXT6 only, right? Quarrel, where from? Nobody says.
Nobody says.
It was from, you have extracted. This quarrel is goes, this goes. Huh? Oh. For the entire, that is the influence of the statement. Court is influenced by that statement.
Made under premise.
Only that much is to be recorded. Thus, another circumstance, the second circumstance relied by the learned trial court, as extracted above, is that before committing the crime, before commission of the crime, a quarrel broke out between the accused persons and the deceased on question of money. Full stop. The accused, A1 and the deceased, a quarrel broke out between, before commission of the crime, a quarrel broke out between the accused A1 and the deceased on question of money. Full stop. None of the prosecution witnesses had deposed as regards occurrence of a quarrel between the accused, A1 and the deceased on the question of money. Full stop. In absence of any such testimony, we are persuaded to form a view that the learned trial court had relied on the story relied on the contents of EXT6 to draw such circumstance, which is not permissible under the law, which is not permissible under Section 27 of the Evidence Act. Full stop. Para. Another circumstance referred by the learned trial court as well as by the prosecution is that the weapon was recovered by the IO at the instance of the accused, A1. Full stop. The accused, A1 did not state anything as regards the place where did not mention about the place where where a Siprang was concealed, nor any of the prosecution witnesses, who were present at the place when the dead body was recovered on the had deposed to the effect that the Siprang was recovered after being shown by the accused, A1. Full stop. In such view of the matter, the drawing of the circumstance that the Siprang was recovered by the IO at the instance of the accused, A1, in our considered view, is a perverse finding. Full stop. Needless to say that the prosecution has not laid any other evidence connecting the said Siprang so recovered with the alleged homicidal death of the deceased. Full stop. It will go. It again. Next is what? Para. Para. Itu naik. Section 8. Section 8. Outcome. uh, the prosecution, before this court, the prosecution has contended that when the accused A1 was taken to the place at Munsi Posti in village, Uttar Kalikhali, Kalikhali, he showed the place. He showed the septic tank where the dead body of the deceased was found. And on that basis, has asked that the such pointing towards the septic tank by the accused A1 is relevant under Section 8 of the Evidence Act. Right? Full stop. It has been further contended that on that day, the accused A1 confessed to the fact that he had killed the deceased with a chiprang, and after killing, he had dumped the dead body in the septic tank, and such confession is admissible because the confession was made before in presence of the magistrate. Full stop. That the contention that the confession made by the accused A1 before a magistrate, that is the additional deputy commissioner, and such confession is admissible under Section 26 of the Evidence Act. After consideration, fine deserves to be rejected for the reason that the magistrate before him such confession was allegedly made, did not depose, did not enter into the witness box to testify on that aspect. Full stop. Anis to what আছে নেকি? Anis to what আছে নেকি? Anis বুলি এটা আছিল। Anis বুলি এটা আছিল। Anis বুলি কথা এটা আছিল, থাকিব পাৰে মই সেইটো কথা। মস্ত নেকি এইটো? আছে। আৰু মাত্ৰ হেৰি দিছিল নহয়, আমাৰ ভূঞাই কোনটো দিছিল সুপ্ৰিম কোৰ্ট? You give a judgment, no? Venkatesh. MS Bhuya? Venkatesh. Which one? We have it. Mota আছে। Venkatesh, no? In Venkatesh.
2005 volume 7, correct? Yeah.
I'll have it.
For the other part, for the part that the dead body of the deceased was recovered. And that the prosecution witnesses who were present there testifying to the effect that the accused, A1 pointed to the septic tank wherefrom the dead body was recovered is relevant. Statement to armor it is true that is relevant under section 8 of the Evidence Act. Section 8 makes the conduct of an accused person relevant, if such conduct influences or influenced by any fact in issue or relevant fact, full stop. It could be either a previous or a subsequent conduct. Full stop. The conduct, in order to be admissible, must be such that it has close nexus with a fact in issue or relevant fact. Full stop. ইয়াতে কৈছিলে কোনটোত কৈছিল যে দুটা কথা যে সুপ্ৰিম কোৰ্টত আছে সুপ্ৰিম কোৰ্ট দেখালে যে এইটো ন এইটো Sahaja, who said Sahaja?
Mr.
Tiwari. Okay. In A.N. Venkatesh and another versus State of Karnataka, 2005-7 SEC 714, relied on by the prosecution, it has been observed that the evidence of the circumstance, simpliciter, that the accused pointed to the police officer, the place where the dead body was found, and on their pointing out the body was exhumed, would be admissible as conduct under section 8, irrespective of the fact whether the statement made by the accused contemporaneously with or antecedent to such conduct falls within the purview of section 27 or not. Full stop. The evidence of the investigating officer and the prosecution witnesses, named therein, that the accused had taken them to the spot and pointed out the place where the dead body was buried, is an admissible piece of evidence under section 8 as the conduct of the accused. Full stop. As we have already found that the section 27, the no value can be attached on the point of discovery of fact under section on the basis of the statement, confessional statements of the accused A1 EXC6 on the basis of section 27 of the Evidence Act. We have already found, huh? Full stop. What from the fact that the accused pointed to the place where where from the dead body was recovered. কি করলো? It does not suggest that no. The same does not go to indicate anything about his involvement in the concealment of the dead body. Full stop. Mere discovery cannot be interpreted as sufficient to infer authorship of concealment by the person who discovered the dead body. Full stop. Apart from the discussion already made in paragraph so and so herein above, the decision in Sohaja alias Sahajahan Ismail Mohammad Sheikh versus State of Maharashtra, কোনটো limited, কোনটো আছে 2022 10 scale 290 2022 10 scale 290 এটা চাই ল'ব লাগিব, can be referred to. Paragraph 45 can be referred to. In paragraph 45, the Honorable Court has observed as under, paragraph 45. From the above proposition, it can, from the fact of pointing towards the septic tank where from the dead body of the deceased was recovered by police, two inferences are possible. Firstly, the accused, A1 would have derived the knowledge of the existence of the dead body at the place through some other source. Two inferences. Secondly, the accused, A1 might have even seen somebody concealing the dead body in the septic tank. And thirdly, the accused, A1 himself after killing the dead body, concealed the dead body in the septic tank. Full stop. Therefore, it cannot be presumed, outrightly presumed or inferred that because the dead body was discovered from the septic tank on being pointed out by the accused A1 that he was the person who had concealed it. Much less that he had killed the deceased. Full stop. Therefore, going by the analogy laid down in Shah Jahan Supra, even if the discovery is accepted, discovery the fact of recovery from the septic tank is accepted, what emerges from the substantive evidence as regards the discovery of the dead body is that the accused person A1 disclosed that he would show the weapon. He knew the place where the dead body was concealed. Full stop. From the above, this piece of evidence is the only substantive piece of evidence which is relevant under Section 8 of the Evidence Act. Full stop. Para. The see the circumstances. It would be discarded confidential statement to confidential only the remaining circumstance, the other circumstance from which the conclusion of guilt was drawn by the learned trial court is the confession of guilt made by the accused person, A3, who had already expired prior to the delivery of the judgment, impugn hearing during trial again. During trial. Full stop. The said circumstance we find that the said circumstance and we find that during the course of investigation, the statement of the accused person, A3, like the accused person A2, was recorded under Section 164 CRPC by the what is it? Page. On
Page 130, my lord.
25, 11, 25 or 25,
11, my lord.
11, 2016 by PW 16, Dr. N.C. Bhuya, Judicial Magistrate, first class. First class? Why not?
Yes, my lord.
Please, full stop. But when PW 16 deposed before the court as deposed before the court, comma, he did not depose anything as regards the confessional statement of the accused person, comma, A3 recorded under section 164 CRPC. Full stop. Even otherwise, comma, hey, even otherwise, comma, even otherwise, comma, such a statement cannot be admissible as a previous statement under section 32, 1 of the Evidence Act. As a dying declaration. First stop. Under section, a dying declaration is admissible under section 32, clause 1 of the Evidence Act. And it lays down that statement made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, comma, in cases in which the cause of that person's death comes into question are relevant, whether the person who made them was or was not, comma, at the time when they were made, comma, under expectation of death, comma, and whatever may be the nature of the proceedings in which the cause of his death comes into question. Full stop. In the statement recorded under section 164 CRPC, the accused person, comma, A3, did not depose anything as regards his had deposed as regards the date of the disease and not in connection, not anything as regards his cause of death. And as such, comma, the such confessional statement could not have otherwise relied upon by the prosecution as well as by the learned trial court to take it as a circumstance as a circumstance in the chain of circumstances. Nine. Nine, না? তো আছে এই পার্টটু ও এই পার্টটু তো বলেই এটা পার্টটু বলেই না কোনটা বলবে ইয়াত আছানে এয়াৰৰ পৰা ওলাইছিলে এটা মই মাৰ্ক কৰি থৈছিলো এয়াৰত এটা আছে চাওকচোন এইটো নেকি এইটো এইটো নেকি এয়াৰ নেকি বলবীৰ MS ভূঞা এইটো মাজত হ'ব দেই পিছত সোমাই দিম MS ভূঞা has relied upon the decision 1, 2, 3, 4 a 4 years decision of the Honorable Supreme Court in Balbir Singh versus State of Punjab, AIR 1957 SC 216, to contend that though in the confessional statement EXT 11 of the accused person, though from the EXT 11, the inculpatory part of the accused A1, so far as the charge of murder is not admissible, would not be admissible in evidence, but the inculpatory part of the said statement, wherein, apart from implicating the accused person A1, he himself implicated, implicated himself for a charge under section 201 IPC. Such inculpatory part would be admissible in evidence. Right? Okay. In Balbir Singh, from the ratio laid down in Balbir Singh Supra, it appears that if a confessional, if a confession is found to be voluntary and true, কোনটো part আছে এইটোৰ? Para 15. কোনটো part আছিল? এইটোত আছিল জানো? এইটো। Which part?
I relied on para 14.
Para 14.
14. Para 15.
On racial laid down in so and so. From Balbir Singh Supra. The proposition which emerges is that in appreciating, in evaluating a confession statement of an accused, the inculpatory part can be accepted as evidence, leaving aside the exculpatory part. Full stop. The decision in Balbir Singh no, yeah, full stop. But in the case in hand, we have already found that the confession statement EXC6 is a statement recorded post discovery, and as such, the principle, the rule of evidence enshrined in Section 27 of the Evidence Act itself is not applicable. Full stop. In such view of the matter, the decision in Balbir Singh Supra would not come in aid of the prosecution.
One
In-
judgment I have brought.
How much?
Haricharan to be 5 judges.
Huh?
Haricharan to be. They have brought it so.
Which part?
Roshit para 12 onwards.
But we have discarded
Roshit discuss.
post discovery.
Since that
Okay, we'll read it for further reference.
Roshit.
We'll not quote it.
My lord.
Because we have discarded for the reason that it is post discovery.
Roshit. May not be written.
Discovery should precede,
My lord.
but here it is cart before the horse. Huh? Okay. Yes, Mr. Tiwari, anything more which is not recorded?
Now everything has come.
Huh?
Everything has taken care of.
Yes, Mr. Mohanto?
Everything is perfect.
Roshit 106. and
I have
34.
discarded. Okay, I'll say, because I have said already, why 106? Because prosecution has to prove its case, then only the onus shifted.
And my lord, one part, my lord, what your
Uh,
chief has already observed, my lord.
Mm,
With
1
full-
minute. Though the prosecution has pressed that the rule of evidence contained in Section 106 Evidence Act would be applicable in this case, we find no applicability of the rule of evidence contained in 106 of the Evidence Act in the case in hand. Full stop. The rule of evidence contained in 106 Evidence Act gets operational only in cases where the prosecution could be said to have succeeded in proving the facts from which a reasonable inference can be drawn regarding the guilt of the accused. Full stop. In the discussion made above, we have found that apart from the substantive piece of evidence in the context of Rule 8 of the Evidence Act, the other circumstances are the prosecution has not been able to prove the other circumstances by credible evidence. Full stop. In such Rio the matter, the obligation to offer a plausible explanation by the accused under Section 106 Evidence Act as regards the circumstance under which, as regards the circumstance under which the deceased died could not have been shifted, could not have been said to be shifted to him. Full stop. Where? In this view of ours has stemmed from the observation made in Sarad Bidivai Sarda Supra that in a case resting on circumstantial evidence where various links are found to have been satisfactorily made out and the circumstances point toward the accused as the probable assailant, with reasonable definiteness and in proximity to the disease as regards time and situation, then only absence of explanation from the end of the accused would operate as an additional link to complete the chain. Full stop. Para. Uh, একটু লিখে দিব scene of circumstance. Though, because of the fact that the deceased, who was a head mason, comma, where and the who was a head mason and the accused persons were his co-workers in a contract in a contract work which was undergoing at the relevant point of time, and the factum of that points factum of death of the deceased points a needle of suspicion towards the accused persons as the probable assailant, comma, such suspicion, comma, however grave it may be, comma, cannot take the place of proof. And there is a big difference between something that quote unquote may be proved and something that quote unquote will be proved. Full stop. In a criminal trial, comma, suspicion, no matter how strong, comma, cannot and must not be permitted to take the place of proof. Full stop. In a criminal trial, in a criminal case, comma, no, sorry, the principle of criminal, one of the fundamental criminal principles of criminal jurisprudence is that the court has a duty to ensure that mere conjecture or suspicion shall not be allowed to take the place of legal proof. Full stop. The large distance between may be true and must be true must be covered by way of clear, comma, cogent and credible evidence produced by the accused, comma, before an accused is held to be guilty of a crime. Full stop. Another golden principle which runs through the which runs in administration of which runs through administration of justice in criminal cases is that if two views are possible on the evidence adduced in the case, comma, one pointing towards the guilt of the accused and the other to his innocence, comma, and the view which is favorable to the accused should be adopted. First of, and this principle assumes more significance in cases wherein the guilt of the accused is sought to be established by way of circumstantial evidence. First of, testing on the parameters on which a case resting on circumstantial evidence comma, the considered view that the prosecution in the case in hand, has not been able to prove the required circumstances by all the required circumstances by clear, cogent, and credible evidence, and thereafter, to complete the chain of circumstances to point unerringly that it was the accused appellant's hearing who were the probable assailants and were the perpetrator of the crime of murder, perpetrator of the perpetrator of the crime of homicide till death of the deceased. Full stop. As a corollary, the accused appellants are found entitled to the benefit of doubt. Full stop. In such view of the matter, the judgment and order of conviction and sentence passed by the learned trial court, it is so and so, is found unsustainable law. Full stop. Extending the benefit, full stop. Accordingly, the judgment and order dated of conviction and sentence passed by the learned trial court in session case number so and so is set aside and passed. Resultingly, this criminal, both the criminal appeals are stand allowed. Full stop. The accused appellants are to be released from custody forthwith if they are not, their custody is not required for in connection with any other case or purpose. Full stop. Appreciate Tiwari, Mohanto, and Misikuri case records of so and so be sent back forthwith.
My lord, the court is not interfering with the
Both
compensation.
amicus.
Yes, my both America. My lord, this victim compensation, my lord, that this court is not doing. That line is required to be placed.
A victim commission Kalijata Disilu. Anything has recorded by the trial court?
Yes, Kuruchi.
Which part?
My lord. Para, my lord. 71 page 90.
Kalijata Disilu, Kalijata Kali diction Disilu. Kalita diction Disiluka, Kal Disilu. Also read. We retried. I took a incorporate for it.
Direct to make an enquiry, I think if not already paid.
If not already
Yes.
paid,
Yes.
inquiry thereafter 357A and extended victim compensation scheme.
Deeply
Wife
obliged.
to deliver or minor children, if any, and parents, if any.
Deeply obliged.
এটা আছে থৈ দিয়ক মই পিছত আপোনাক দেখুৱাই দিম হা এইখিনি সামৰি থৈ দিব ছাৰতটো থৈ দিব এইটো এইটো লাগিব এইটো ন 19 এইটো এই যে পেৰা 19টো কৈছিলে ন এইটো লৈ থৈ দিয়ক পাহৰি যাব নহ'লে 19টো এই যে গোটেইটো এক্সট্ৰেক্ট কৰিব নালাগে এইটো আছিল সঞ্জয় ঠাকৰা না এইখন মোৰ নোটটো ৰাখিব। Oh, Mr. Tiwari, don't expect it to today or tomorrow. Please, Monday. Huh? Huh? কৈ থলো বাৰু মানুহবোৰে নহ'লে আমি কৈ থৈ দিওঁ নহ'লে মানুহবোৰে যাই চাৰ্টিফিকেট কৰি এপ্লাই কৰি বহি থাকে তাৰপিছত আমাক ডকুমেণ্ট আমাৰ এণ্ড কৰি আহিব। Yes.
Did you item number 1?
Yes, what are the saga? We'll hear it on 3:13.
Yes, only we
First,
confirm 30, no, not
we'll
other.
concentrate. Other things are,
Yes, other, my lord, yes.
Friday.
no, yes, just we'll hear. If Friday, I don't think I'll be there. So we can only postpone it to tomorrow.
Yes.
Next week, we don't think we are sitting together. So we'll have a brief idea what Mr. Mohanto is going to say.
My.
Then you can rebut or you can oppose. And we can continue tomorrow as a first item because we can't help it. That was continued since yesterday.
Yes, no.
Lots of
problem.
points were involved.
My lord, no problem.
Yes.
Lordship, on the last occasion, ask us to.
No,
go
I
through the records.
just
No, records,
indicated
my lord.
4 options.
Lordship.
Yes, all the, I got it, my lord. Yes, all the 4 options, my lord. In fact, my lord, that is answered in the very last judgment, my lord.
Very last. Which
Very last,
one?
not the judgment, but that is Naresh Kumar, my lord.
Norris.
Naresh Kumar.
Norris. Norris.
Naresh Kumar, my lord. Actually, Naresh Kumar, man, quoting the main decision is Raj Kumar. That is. Yep. Before Naresh Kumar, my lord, your lordship kindly take up, my lord, 2000.
1 minute, 1 minute. Norris Kumar, what was it?
Naresh Kumar, my lord, that is, the judgment was, my lord, pronounced from 8 July 2024. Criminal appeal number 1751 of 2017. Naresh Kumar versus State of Delhi. Yes, ma'am. Copy to assign. There are 6.
No, no, what is the point decided there?
My lord, regarding 313, my lord, your lordship kindly, what are the, as your lordship got, my lord, that is para 17 of the, my lord.
Okay. Para 17.
Para 16 of the judgment, my lord. And
These
that
are
is- Actually, that is quoted from the another judgment, Rajkumar versus State of NCT Delhi. That is AIR 2023 Supreme Court 3113.
Air
AIR
Raj Kumar.
Rajkumar, my lord. AIR 2023 Supreme Court 3113.
AIR tonight, Supreme Court SCC. Hey,
Live law also it has a report.
hey, that 313 এটা থৈ দিয়া আছিল ক'ৰবাত। ইয়াতে আছে নেকি চাওকচোন, সেইদিনাখন থৈ দিছিলো ইয়াতে। Rajkumar,
versus state of entity.
State and city of Delhi.
Rajkumar, Naresh Kumar, I know. Ah, Rajkumar. Ah, একটু Rajkumar. একটু এফআইআর আছে এখানে থৈ দিয়ক বেলেগে এইটো থৈ দিয়ক একটু লাগিব কেতিয়াবা
Para
Rajkumar.
Yes, para, your lordship kindly state where goes to para 17, my lord, in my Manupatto, it is Rajkumar, my lord. In Monopatto, it is para 17, 16. And my Monopatto also para to the para 17, my lord.
Yes, yes, that day I read.
Yes,
I
ma'am.
read. What the question is here. Whether because a decision is an authority, what it decides. It cannot be taken picking up one thing or another. Now read paragraph 5.
Of the
That Rajkumar. What was his role in that case? This read paragraph 5 of Rajkumar.
It is
Right.
submitted that the only circumstance appearing in the evidence against the appellant that he was standing outside near the gate of the lady with a kata was not put in him in the statement under section 300 of the Code of Criminal Procedure 1970. He submitted that this argument was specifically canvassed before the High
No,
Court.
you just stop there after other part. Now, there were 6 accused.
My lord,
5 were there inside the house committing the crime.
my lord,
Only out of many witnesses, one said this man was standing outside the house.
my lord.
He was not a direct perpetrator of the crime. He was not an assailant. He was just standing he was roped in as a accused by the aid of either 149 or whatever.
My lord.
He was standing outside the house. Now, so it was in that context, that paragraph 17.
The 17, my lord, that law
Ah.
consists laid down by this court can be summarized as under. That,
Huh.
that it is truly that the trial court is put a your lordship kindly spare us.
No, paragraph, I am saying about paragraph 17
My lord.
of Naresh Kumar. That may not be truly applicable, directly applicable in your case.
No, that I summarize, my lord.
Summarize part, yes.
Summarize part, your lordship kindly, the law which is, my lord, laid down, my lord, your lordship kindly see that part.
Huh. Rajkumar, that part,
Rajkumar, my lord.
I am agreeable to that part,
Yes.
but not directly
No,
agreeable
I'll come
to
that.
paragraph 17.
Yes,
Am I clear?
yes, yes. Clear.
Because the role here,
Yes, that is different, but
ah,
what will be the question, my lord, how, my lord, what will be the
yes, that
313, what will be?
that is, yes.
It is the duty of the trial court. It is a common, my lord. In
Huh.
fact, my lord, why I am reading, my lord, that Rajkumar's judgment, it was, my lord, sent it to all the, my lord, trial court by the Supreme Court, my lord, as a direction, my lord. The law consistently laid down the court can be summarized as under. It is the duty of the trial court to put its material circumstance appearing in the evidence against the accused, specially, distinctly, and separately.
Hmm.
So, your lordship kindly see these 3 words, my lord.
Hmm.
Specifically, distinctly, and separately. Here in this case, in my case, my lord, how I am prejudiced, my lord. Only 2 questions put. One is regarding 300, one is regarding my lord, circumstance, and one is regarding.
Here, photo guideline. এইটো ৰাজকুমাৰ কোন পেৰাগ্ৰাফত কৰিলে বা 17
Rajkumar, Probably para 16, my lord.
Huh?
Para 16.
Right, paragraph 16. ভুল হয়েছে এটা বেলেগৰ পৰা কপি
That Rajkumar is quoted in, my lord, that is
Hmm.
known as Kumar's case, my lord.
So what is the prejudice?
My lord. Yes, my lord, I will come to that, my lord. These are the things, my lord, that has to be, my lord. Your lordship kindly see only one question, summarize everything. Whose evidence say what? That is not been put into me, my lord. Your lordship kindly see that only, but in the judgment, my lord, only, my lord, confessional part. But confessional part already, my lord, I am submitted that whatever I have confessed, my lord, that cannot be, my lord, it cannot be taken into account, my lord. Because police officer is there, my lord, there is a judgment, my lord, how it is, my lord, dealt with. But that was the question, and only on basis of that, my lord, my conviction is maintained. So far is 313, my lord, main para, my lord. Apart from that, my lord, PW5, PW7, and PW11, they says against me, my lord. But there is no specific question what PW5 says, PW7 says, and PW11 says to me, my lord. Only summarize all, only one question, my lord. Evidence says you have done so and so. Only that, my lord. So that way, my lord, I am unable to answer, my lord. So that is
Because
that.
there is a question which followed thereafter, perhaps.
No, my lord.
Let us see.
Only two questions put to me, my lord.
Let us see. আসলটো দিব আসলটো একদম আসলটো দিব রেকর্ড At least say question number 3. Do you have anything else to say?
No, that is a common question. That is, my lord, that regarding, my lord, my.
You can extort everything, whatever is in your mind.
But what is the circumstance relied by the prosecution has to be put on to me by the prosecution, my lord.
But that is also laced with a rider that prejudice. Now, you waited after 313 for 20 years.
No, definitely not that. No, my lord.
That
Why?
is also a
Yes, yes.
circumstance that 1997, 313 was recorded.
Yes.
Then everything went inside the cold storage.
After 20 years, again
It was revived.
and the
So
fourth,
20 years, there was no prejudice, no allegation of prejudice.
no, my lord, judgment was not delivered, my lord. It, ultimately, my lord,
No, you cannot have waited for
how can I, my
judgment.
lord?
You said no defense evidence,
No,
nothing to
no,
say.
your lordship kindly see my statement of 313 statement was recorded in 1997, my lord.
Yes, that is what I pointed out. 23rd June 1997.
97.
Hmm.
And that's
In a language understood by you, your Ganesh Tati
my lord,
asked in Assamese language.
my lord.
So it was loud and clear that
No, my lord, but mandate of that judgment, if your lordship go by the mandate of the
We-
Rajkumar Jain,
Rajkumar is not totally saying that
no, what
clause 4. We are testing this case as a whole, not only from one,
my lord,
not only from clause 1, paragraph 16,
my lord.
1, 2, 3, 4, 5, 6.
Correct. Everything.
Ah,
I will come to
We
one.
are not only with only one. Am I clear?
My lord. No, if your lordship kindly, if you go by that clause 1, that specifically, distinctly, and separately.
Hmm.
But that was not done in my case, my lord.
Okay. Then come to clause 4.
My lord. Failure to put material circumstance to the accused amounting to a serious irregularity. It will vitiate the trial. It will vitiate the trial if it is shown to have been prejudiced to the accused. So my prejudice is that, my lord, I am unable to give answer. It is not put on me, my lord. So that's why I am prejudiced, my lord.
That is the what is the prejudice? That will not do. Because just because questions were not put to you, specifically, distinctly, that is an irregularity. Now, question is, what is the prejudice? just because questions were not put to you distinctly, specifically,
My lord,
so that becomes an irregularity.
correct.
And
No.
just because it was not put, it was not. But question is of vitiating their trial. Now, what prejudice?
Prejudice mean, my lord, I am unable to answer, my
That
lord.
is the
I am unable to answer. If no, that is not even.
only that is the submission, then would be
Then, my lord,
failing in our duty because we find that
no, then, my lord,
It
how
is a-
can I explain? How can your lordship kindly see another judgment of the apex court, my lord?
yes,
I'll please, my lord, another judgment, my lord.
yes,
Mr. Mahata?
my brother is asking something.
You are referring to the evidence given by PW5, the eyewitness, correct?
My lord.
According to you, it is not put in question that PW5 has said so and so.
My lord.
This is the point that you're trying to draw
No,
home,
they are,
correct? One of the points.
yes.
Now, if you go to that question
My lord.
number one.
Hmm. Yes, correct. I have seen, my lord. Only time is
contents
mentioned.
of the, what the eyewitness have deposed in the court has already been put in that.
Only
question.
one question, my lord. Your lordship kindly see.
It, the three eyewitnesses, it has been clubbed and put as
That
one
cannot be,
question.
my lord.
But
That
the
is the law.
gist of the, whatever the eyewitnesses have seen is already put to you.
No, no, that
So
I
how can
understand,
you
my
say
lord.
the accused has
Your
been
lordship
prejudiced?
kindly, if you go by the mandate of this, my lord, that has to be separately, you have to be put, my lord.
No, that is not the mandate. That is one, clause one. Prejudice is another one. What you have
Because, my lord,
pleaded otherwise?
313 is not a mere formalities, my lord. It is
Ye-
there is a right to the accused, my lord.
Absolutely, absolutely.
So that's why, my lord.
There is no dispute to the said
My lord.
proposition.
But I'm
Because
that convinced, my lord.
something in CRPC or something
No, it
in
is,
the in
these are all-
statute
these are all,
that some are treated to be curable
my lord.
irregularity, some are not curable irregularities, and some are illegalities. Now, this is not illegality. Now, this comes within the form of irregularity.
My lord.
And irregularity, commission of irregularity will not vitiate the trial unless
Prejudice.
prejudice is shown to have been caused, and it should be effectively caused. That is what we are trying to say, because CRPC
No,
460.
CRPC, my lord, regarding 313 CRPC is, my lord, totally not, these are all judgment law, my lord.
Judgment
These are all
law.
judgment law, my lord. The
But,
whatever
still-
313 all
Still,
judgment
I
law.
don't remember everything in CRPC. So let me have a look. 463 and 460
Any circumstance.
irregularities to issue so and so. 460 irregularities which do not vitiate. Irregularities which vitiate. Nothing there.
But in 313, it is there to explain any circumstance
Ah.
appearing to be the evidence against him.
Let us see 313,
65.
465. Okay.
Continuous sentence when reversible by reason of error, omission or irregularity.
A failure of justice. That is what?
Yes.
Now, whether failure of justice has occurred here. Accused shall not enter by repeating to answer the answer given whether may be taken into consideration from put in evidence against them to protest. Okay. This was. And you did not also point out the defense counsel could have suggested the questions, relevant questions, because defense counsel is also given the liberty to prepare the defense question under section
That is
3.
why, my lord, I am submitting. That is why in 313 should be more cautious, my lord, because my lord, my counsel is not been cross-examined, called the eyewitness. Then, my lord, that question has to be put, my lord, more by the court, my
Now,
lord.
please see subsection 5
My lord.
of section 313. Why court will ask that question,
No, that-
Mr. Counsel?
No, no,
I have not
not-
heard that.
No, that I am not, the circumstance has to be, my lord. Circumstance, my lord, otherwise,
That
because I am not
that-
getting any defense, my lord, that
it
means.
is presumed that who has the courage to conduct a criminal trial as a defense counsel is presumed to be aware of all the knowledge.
No, my lord.
Initially, in our practice here, we
Probably,
could
these
not
are-
master the
No,
courage
that is the
to-
reason, my lord,
to-
now, my lord,
to-
now,
to
nowadays,
act as a defense counsel.
my lord. No,
After
my lord,
few
let
years,
us see kindly, what type of defense counsel he is, my lord? He's not been, my lord, cross-examining the eyewitness, my lord. He was, my lord, state counsel appointed by the amicus curiae, probably in the court below, my lord. No, that is why, my lord, Supreme Court is very vigilant last several occasions, my lord. While choosing a defense counsel, it will be more cautious. That's why some guidance has been framed, my lord.
no, Mr. Mohanto.
No, my lord,
As a-
suppose.
because in our initial years of practice, we did not master the courage to cross-examine a witness. Only first after second year, say, mainly in NI cases.
My lord.
Then after few years, we could master the courage to cross-examine a witness in a trial involving a charge of murder. Right. So, mastering a courage to act as a defense counsel in a case of murder, it is presumed that defense counsel had the requisite expertise to
Correct.
conduct a murder trial.
Correct. But
Now, there cannot be a duty for the trial court to examine why your counsel did not examine.
no, my lord,
Cannot be,
No, I am-
Supreme Court cannot lay down a law like that.
no, nowadays, my lord, I'll place that judgment, my lord. Now, what is the guideline frame regarding appointment?
I
of the-
know.
That's,
That 10 years experience, so and so,
Yes,
these are the guidelines. Right.
no, otherwise, what type
no,
of advocate he is, my lord?
That question cannot come. What I am saying, that court will ask a question that PW6 is an eyewitness and your defense counsel did not cross-examine him. No, that cannot be a question.
No, I am not on that. That's why, my lord, circumstance which was relied by the prosecution against him has to be put in the 313, my lord. Your lordship kindly see, he do not know, my lord, what say who against him, my lord. That was, my lord, actually, that is the reason, my lord, why 313. And even in a murder case, my lord, there are two questions put, last two questions are not formal question, my lord. Anything do you have to say, any evidence, that is the formal question. So only two questions put here, my lord.
No, those are relevant. The question number 3
My lord.
is very pertinent.
But yes, but always there is a formal.
Because there he can say anything which comes to his mind as an explanation. The other question should be specific to the evidence appearing adversely against him in the prosecution.
Prosecution, my lord.
But this question is quite general.
My
It
lord.
is quite open.
Yes, wide open.
Question number 3.
Yes, my lord.
He could have provided all the explanation there, because I can show you at least from today's cause list 3 cases where the accused has provided the explanation as a last in response to question number 3.
My lord.
Okay, show us that page the how. It is that I know where the fault lied,
My lord.
which we cannot say,
That is.
but we have to decide it legally.
No,
Legally. Say 5 photo আছে নেকি 4 to goal 5 to আছে নেকি 6 to sound 4 to goals I guess 6 to sound because it was open in question number 3. It was a free run for him.
Page 38.
See, anything to say? Yes, I did not kill Vishnu intentionally. On the day of occurrence, he came to my house with an intention to say abuse, outrage the modesty of my wife. When I went to the garden to fetch firewood, he screamed, and upon hearing her scream, when I returned home, I saw that my wife so-and-so was torn. Tried to dissuade him, but he attempted to assault me. I pushed and shoved him, then he got hit with an axe. I got hit. So, exception comes.
Yes, my lord.
Three
His
exception, 1 or 4 would come, and it would come within the might come within the exception and 304. So this is the way.
That means, your lordship, my lord, that because since that question is put, the prejudice has gone. That question is put,
Huh?
my lord, that will be difficult to accept, my lord. For me, my lord, at
Which
least that if the question number 3, since question number 3 is there, then my lord, other question, that's why I'm not, I'm not.
No, I'm not saying that. We are
My lord.
deliberating, Mr. We are not arriving at
No, my
any
lord, normally,
finding.
my lord, normally for the first time I have seen that, my lord, in 302 cases, my lord, in 3 questions, this,
Yes, I
and
have
I have
also
not
seen.
seen, my lord.
No, I have also seen. I have also seen. Now, question is to decide.
My lord.
To
No, my
decide on
submission
what.
before your lordship, since they are separately, that not distinctly and separately, it was not put to me, I am unable to give the answer, and that way I am prejudiced. That is my answer, my lord. No, only on 313, but other I will not go. Other I will not go,
Other is credible evidence,
my lord.
along with res judicata. Along with res judicata.
My lord. No, that is true, my lord. One point of time. Except this, my lord, I have nothing, my lord. Except this, I have nothing.
And
But
defense counsel choose not to cross-examine the direct eyewitness.
and that part I cannot improve now, my lord.
No, yes. No, we have to be concerned with everything.
Yes, obviously.
This
my
side, that side.
That's it. And last 36 years, my lord, your lordship kindly that I can understand, my lord, 313 recorded after 20 years judgment, my lord.
That is the greatness in Karbi Anglong. We have been finding cases. No, in fact, I did an appeal. At the time of Commission 5, they were about, say, ranging from 16 to 20. By the time I preferred the appeal, all were in 60s.
Here he is 62, my lord.
At the time, they were youth
Yes, my lord.
from Karbi Anglong, right? At the time of the earliest commission of crime. And by the time I preferred the appeal and contested the appeal, 40 years gone by. They were in their 60s. Karbi Anglong.
Here also, my lord, he was 24 at the time.